You've gathered your documents, hired a lawyer, and filed your petition. But then your lawyer says we need to serve the summons to your ex-husband in Italy. Suddenly, your case feels like it's stalled. Why? This delay is rooted in the fundamental legal concept of due process. Under Rule 14 of the Rules of Court, Philippine law requires that the respondent, your ex-spouse, be officially informed of the case. While you might see this as just a simple notification, the court views it as a formal summons. Because a divorce recognition legally terminates a marriage bond, the court cannot alter your civil status without providing the other party a fair opportunity to respond. If your ex-spouse lives abroad, you must undergo extraterritorial service of summons. While having their specific address is a huge advantage, the how depends on the country they live in and the specific preferences of your presiding judge. Despite the availability of modern courier services, many Philippine courts still favor the tried and tested method of international registered mail. While the 2019 Rules of Civil Procedure now recognize accredited couriers, many judges still treat the physical return card, the iconic red card signed by the recipient, as the gold standard of legal proof. The court relies on this card because it provides a clear government-stamped paper trail for the case folder, ensuring the recognition of foreign divorce meets the requirements of due process. However, on this note, it is worth saying that the case for recognition of foreign divorce falls under what are called special proceedings, involving actions in rem or quasi-in rem under Philippine court procedure. Unlike civil actions, this means that courts can accept the proof of sending out the notice by way of registered mail, taken with the general publication requirement, as sufficient compliance in itself. Since 2020, the Philippines has followed the Hague Service Convention for member countries like the USA, Japan, and most of Europe. However, it is important to have a realistic perspective. Despite being designed to streamline international law, this isn't necessarily a fast lane for your case. The process requires significant paperwork, including specific model forms that must be meticulously filed and signed by the presiding judge, and delays often occur right at the start while waiting for these formal signatures. Once signed, the hurdles continue as the documents travel to the central authority of the partner country, where coordination becomes complex. Strict translation requirements, administrative fees, and international mailing costs can stall the process, while your counsel remotely navigates the specific requirements of foreign authorities, who will not move a single inch until every cent of the required fee is paid in full. In modern practice, many Philippine courts have become significantly more pragmatic when dealing with the realities of international service. Even though private couriers like DHL or FedEx are not officially accredited by the Supreme Court in the strictest technical sense, many judges accept them as a valid and efficient mode of sending notices abroad. This approach works because it is significantly faster than relying on government-to-government mail or the bureaucratic Hague route. The primary benefit lies in the accountability of the service. It provides a real-time tracking and a verified digital signature. When you can present the court with a formal delivery receipt signed by the respondent, many judges will accept this as sufficient proof of service, effectively shaving months of waiting time off your legal timeline. If the country is not a member of the Hague Service Convention, one of the oldest ways is service through diplomatic channels, via the Department of Foreign Affairs. This creates a long administrative chain where the documents must travel from the Philippine court to the DFA in Manila, then to the Philippine Embassy or Consulate with jurisdiction over the respondent's location, and finally to the respondent's specific address. The reality of this delivery method is often frustrating, similar to the domestic courts, and the embassy usually defaulting to using local registered mail rather than conducting in-person service. This adds yet another layer of bureaucracy and potential for delay, as you may be waiting for two different national postal systems and a diplomatic office to coordinate a single delivery. Now, let's talk about the cost. This is where the legal budget often begins to stretch, as the cost of serving a summons jumps significantly once it crosses international borders. While a local service of summons in the Philippines involves only local costs, serving court summons to the respondent abroad in 2026 involves a cascade of digital and administrative expenses. You may need to address fees from the Department of Foreign Affairs or the Philippine Embassy, international postage costs, and if the destination is a Hague Service Convention country, like the US, fees payable to the foreign country's officially designated process server. On top of these, legal fees may be involved if your lawyer needs to file the specific request for and to coordinate for extraterritorial service. There are still occasions when the court may eschew personal service or service by mail altogether and instead require service by publication in a newspaper, which involves its own added cost. In the world of Philippine litigation, time is the biggest frustration, and international service can be where momentum is a struggle. Even if you have a perfect verified address, if the Philippine court orders that your counsel must follow the Hague Service Convention, you are likely navigating a maze of bureaucracy. While the Hague process is more standardized, the timeline is still usually months just to receive a certificate of service back in Manila. If your case falls under the diplomatic channel path, the wait may require even more time. In this traditional lane, documents frequently sit in transit within the diplomatic pouch or wait on an embassy desk for processing amidst other consular duties. The most critical bottleneck, however, is the return of summons. By law, the trial cannot move to the next stage until the return is officially filed in the Philippine court records. This creates the longest dead period in a divorce recognition case, a stretch of several months where your lawyer's hands are tied and the judge's calendar is frozen and you are left waiting for a single piece of paper to cross the ocean. Fortunately, as discussed, because recognition of foreign divorce is a special proceeding, it need not be bound by the strict requirements for the return, provided you can prove that the summons actually was sent by way of registered mail to the last known address. In summary, having your ex-spouse's address is a significant advantage, but you must view service as a marathon rather than a sprint. While the law provides pathways to reach them abroad, the sheer volume of bureaucracy means that the fastest way to the finish line is often through cooperation rather than confrontation. Pro tips for a faster process. The power of the co-petitioner. Many people don't realize that unlike cases for annulment, both spouses can actually be petitioners. By signing and agreeing to the petition, they have both submitted themselves to the jurisdiction, the authority of the court, and thus need not be served summons abroad. This is the express lane of divorce recognition. It removes the adversarial hurdle and allows the court to move straight to the hearing. Double check the address. If you must go to the international route, accuracy is everything. A single typo in a foreign zip code or street name can cause the documents to be returned as undeliverable, effectively resetting your timer and forcing you to pay for the process all over again. Manage your expectations with the DFA. Remember that your lawyer cannot rush a Philippine embassy or a foreign central authority. This is a government-to-government process. Once the documents leave the court, they enter a diplomatic channel that moves at its own pace. International service of summons is one of the major reasons why judicial recognition of foreign divorce gets delayed for years. Whether or not you have a cooperative ex-spouse willing to be a co-petitioner or a specific address abroad that requires formal service, you need a strategy. You need experienced counsel. For that, we'll be happy to discuss your situation to secure Philippine recognition of your foreign divorce. Message us at lawyerphilippines.com or email us at admin@lawyerphilippines.org today to map out your timeline and explore your best options. And see you in the next video.